Introduce the president of the Social Law Library, Jeffrey Swope, to give greetings on behalf of the proprietors and trustees.
The English would say.
Thank you. Good afternoon. My name is Jeffrey Swope, and I do bring greetings from the proprietors and the trustees of the Social Law Library. Many of the proprietors, at least, are with us in attendance today. The Social Law Library, compared to the Supreme Judicial Court, is a relative youngster, having been formed approximately 200 years ago, 25 years after the adoption of the Massachusetts Constitution. But if you think over those 200 years of all the lawyers, from the illustrious names like Holmes and Brandeis to the first-year law student who's in a carrel somewhere right now, who've used the assets of the Social Law Library to analyze and to understand the Massachusetts Constitution, you get some sense of the long-lasting and deep connection between the Social Law Library and the Massachusetts Constitution. There's a similar long-standing relationship between the Social Law Library and the Supreme Judicial Court. We've lived under the same roof for many, many years, and we're delighted to live under this particularly splendid roof to which we moved less than a year ago. When this space was being designed, Chief Justice Marshall had the vision of it to be a space for civic events, to look at both historical, current, and future issues of great public importance. And this discussion that we're going to have this afternoon is a wonderful example of the Chief Justice's vision. Chief Justice Marshall.
Thank you so much, President Swope, and welcome to all of you. It is so wonderful to see familiar faces, friends of long standing, and also some new faces. I always love it when I'm in audiences with new faces. I particularly want to welcome back my distinguished predecessor, Chief Justice Wilkins, who had quite a heavy hand in the renovation of this great building, and I'm delighted that he is here today to join us with this. I have to say that I am so pleased to have Professors Amar, of course he's a professor at the great law school, Bill Fowler, Julian Houston, my wonderful colleague who I've known for so many years, and Professors Maier and Wood. I have to say, Julian, I do read your things from time to time, but not with as much pleasure as I do read the writings of Professors Wood, Amar, Maier, and Mr. Fowler. I simply say that as a casual introduction. My role here is simply to say welcome, and I do want to take a moment, and I'm sure Robert would want me to do this, to thank in particular the Charles H. Kloss Charitable Foundation, and to do this in memory of Jim Brink. Jim was such a wonderful part of our legal community here in Boston, and I think that he would be thrilled to know that his memory has been celebrated in this way today. You are here to hear the distinguished speakers, not to listen to me, and so here they are.
Thank you very much. We have a shortage of microphones, so we're just going to move this for Professor Wood. All right, John? And then, can you hear me? All right. I'm the moderator, but I'm going to sit down because this is really to be a conversation. So, thank you, Chief Justice. We're honored to have such a distinguished panel, each of whom, I must say, responded enthusiastically to the invitation to be here today. It was very informal. It was an email or a telephone call, and each one said, yes, absolutely. And most of them said that this would be fun, and I hope it is, and I trust it will be. While the subject of today's program is important and interesting, the overfull crowd here and in the other room can be attributed to the prominence of the panel. So I don't think long introductions are necessary for you, or given how unselfishly they have given their time to us, I don't think that they need long introductions either. Nevertheless, several sentences are in order. From my left, Gordon S. Wood, winner of the Pulitzer Prize and professor of American history at Brown University, has to his credit a number of books, articles, awards, distinguished lectures, and civic-minded activities. He was on as a consultant to the new Constitution Center in Philadelphia, and I was there about 6 weeks ago. What a wonderful facility, and I would encourage everyone to visit. Published this past spring, his most recent book, The Americanization of Benjamin Franklin, is already being honored with awards. For our purposes today, his seminal and sweeping study, The Creation of the American Republic, 1776 to 1787, is the most frequently cited and most comprehensive analysis of constitution making in the Revolutionary era. It is the yardstick by which all other works on the subject are measured. To his left, Yale Law School professor Ahkil read Amar's writing and activities have been of appeal to both academics and general audiences. He has a long list of influential law review articles, law school case books, and the like, plus several works that have appealed to the larger public, notably the Bill of Rights, Creation and Reconstruction, and For the People. You may have noticed his most recent book, America's Constitution, a biography, was praised in the November 6th issue of the New York Times Book Review, and which, as you can see from the flyer on your seats, he's agreed to come back to the Social Law Library in February, to talk in more detail about it. And always the advertiser, we have a list of other events. Cass Sunstein is coming here on November 10th, and if you register by email, you will be on our email invitation list, and you'll get notices, and we'll be able to save on stamps. So please register, please come. To his left is Pauline Maier. She teaches American history at MIT and has to her credit such titles as Colonial Radicals and the Development of American Opposition to Britain, published in 1972, The Old Revolutionaries, Political Lives in the Age of Sam Adams, The American People, A History, and American Scripture, Making of the Declaration of Independence, which was picked by the editors of the New York Times Book Review as one of the best books of 1997. In addition to appealing to general audiences, her books and articles have been nominated for and won prestigious awards from her colleagues in the scholarly community. She is presently working on a book about the ratification of the federal Constitution that is under contract with Simon & Schuster. Julian T. Houston has been a Massachusetts Superior Court judge since 1990, and before that for 11 years as a judge of the Roxbury District Court. Judge Houston's work as a judge have not been limited to the confines of the courtroom. In 2003, he was honored with the President's Award for Distinguished Contributions to Justice from the American Society of Criminology, which, I surmise, recognized his efforts as the founder and inspiration behind such initiatives as Roxbury Youth Works, Inc., a community-based program providing services to young people, the Roxbury District Court Child Care Center, the first court-based child care center in New England, and the George Lewis Ruffin Society, an organization named after the state's first black graduate of Harvard Law School and the state's first black judge that works closely with the minority community and the criminal justice system. A historian at heart, Judge Houston was the moving force behind the Ruffin Society's multi-pronged educational program and traveling exhibit, Long Road to Justice, the African American Experience in Massachusetts Courts. The Massachusetts Historical Society's website currently features a wonderfully rich web version of the exhibit at www.masshist.org. William M. Fowler is the director of the Massachusetts Historical Society and consulting editor of the New England Quarterly. He, too, has titles of relevance to today's topic, including biographies of John Hancock, who parenthetically served as the Commonwealth's first governor under the Constitution we'll be talking about today, and Samuel Adams, who had a thing or two to say about not only the Revolution, but the Massachusetts Constitution. Bill has also been energetically involved in local and national civic affairs, and I know that I speak for Chief Justice Marshall and Justice Cordy and others on the court when I say that he has provided invaluable advice and assistance with this wonderfully restored building, and I'm sure that the leaders of scores of civic organizations, simply too numerous to mention, would sing similar praise. After 7 or 8 very active and successful years at Massachusetts Historical Society, Bill is returning to Northeastern University, where he taught from 1971 to 1978 as Distinguished Professor of History, a well-deserved title, and hence your name tag says Professor, since you're rejoining the ranks. Instead of, when trying to develop the program, instead of asking each panel member to give a lecture, which would be, 5 20-minute orations, someone whispered in my ear that academics are like lawyers and the sweetest voice to their ears is their own, and those 20 minutes could go on to 40 minutes and we'd have a very difficult time. So what we've decided to do is to try to have a discussion, an open, free-flowing, my dinner with Andre type discussion. After reviewing the discussion outline, Professor Wood good-humoredly wrote back that there was so much to talk about that we're apt to end up like Thomas Prince, the 18th century divine who planned to write a history of New England and began with Adam and Eve. He wrote several volumes but died before he got to telling readers about New England. So we all decided that we're going to help each other out, which means help me out, and move the conversation along from topic to topic. But first, let me set the scene with a brief overview so that we all start from the proverbial same page. Although not as far back as Adam and Eve, it is important to understand that the government of Massachusetts Bay had been quite stable since the Charter of 1691, which left alone the strong town meeting government of the prior century. For about 80 years or so, the freeholders in town meetings exercised much control over local affairs and had a strong voice in provincial government. Yes, the governor was appointed by the Crown, but freeholders in town meetings throughout the province elected the House of Representatives, and the council was chosen by the House, even though the governor had some say in the selections. Since the council provided its consent, it served as an important check on the royal governor's appointments, including the colony's judges and sheriffs, who, in turn, appointed juries. This balance of power changed in May and June of 1774 when Parliament enacted the Coercive Acts as punishment for the Boston Tea Party 6 months earlier. Most will remember that the Coercive Acts appointed General Gage as the new governor and essentially imposed martial law with the quartering of troops in Boston. But to use Robert Taylor's phrase, and I see you have his book here, the Coercive Acts also rudely wrenched out of shape the structure of government, the balance of power, if you will, between royal and local authorities. Among other changes, the Coercive Acts replaced the council with royal appointments. This is significant. No longer picked by the popularly elected House of Representatives, the council also no longer could check the governor's appointment of the colony's judges and the selection of juries. The struggle over who controlled the courts and judges was not new, and parenthetically, something that has not entirely vanished either. Indeed, there had been tussles between the governor and the House over judicial salaries, an issue many will recall that became inflamed when Chief Justice Peter Oliver rejected salary from the legislature in favor of that of the Crown. But with the Coercive Acts, the King's governor suddenly had much more power to control policy in the colony through his domination of the council and the court system. Well, the people of Massachusetts didn't take well to the Coercive Acts, and without getting into any detail, this led General Gage to dissolve the General Court in June of 1774. In October, 90 representatives nevertheless met in Salem, went through the charade or the formalities of waiting for the governor to show up to convene the General Court. And then, when he didn't show, resolved themselves into a provincial Congress, which, even though there was no authority giving any legal status, filled in until the next spring. With the shot heard round the world and the battles of Lexington and Concord the following April 19th, the Provincial Congress deposed General Gage. So now, the General Court was dissolved, the governor was deposed, and the Provincial Congress had no formal authority to govern or even exist. What to do? The following month in May, John Adams submitted a resolution to the Second Continental Congress for authority to form a new government. Sounds very formal, but he remembers that he harangued the delegates about this. Critics called Adams' idea a machine to fabricate independence. What was going on here? Afraid to go it alone against the Crown, Massachusetts wanted the backing of other colonies to form its own government. Yet the majority in Philadelphia still had hopes of a peaceful resolution. So instead of endorsing the formation of entirely new government, the Continental Congress recommended that Massachusetts essentially pretend that the 1691 charter remain in force, have the towns elect new representatives, which in turn should elect a new council, and then wait for the king to come to his senses and appoint a new governor who would respect the 1691 charter. Although Massachusetts followed this legal fiction, it did not at all sit well with many of the towns, most especially those in the western part of the state, known as the Berkshire Constitutionalists. Insistent that the 1691 charter was dissolved by war, the Constitutionalists defied its validity and closed the courts to show that the locals should run the machinery of government, of their own government. Much more, I assume, will be said about the towns during this discussion. As you know, things got only worse, so much so that in May of 1776, about 2 months before it formally adopted the Declaration of Independence on July 4th, the Continental Congress finally gave up hope of reconciliation and advised all the provinces to establish new governments. So let's stop right here. We're all on the same page, and let me turn to the panel. I have a ton of questions. First of all, Professor Wood, what happened? What happened? You know, the Continental Congress says, go on out and make your own governments. Our Constitution, final Constitution, you know, wasn't established until 1780. Did the other colonies kind of twiddle their thumbs?
Well, the May resolutions, which were the May 1776 resolutions, were the work of John Adams. And his colleague said to him, this is tantamount to independence. He said, no, he says, it is independence itself. He said, because Adams felt that if the colonies adopted new governments, they would never go back to the crown. And from these resolutions, people in the various states began planning to make new governments. In my own state of Rhode Island, they claim Independence Day is May 4th, which is a little bit of a but there was a resolution in the Rhode Island legislature that the crown ought to be eliminated from the charter. And in fact, in Connecticut and in Rhode Island, both of those colonies were charter colonies. They had a written document. And they simply went through those documents and crossing out every reference to King George III. And that became their constitutions, really, until into the 19th century for both of those states.
When you go to the display, just let me interject, you'll see on some of the writs where they crossed out, in May of the same year, Massachusetts passed a resolve or legislation to say that we should cross out on the titles, on all the writs, the name of the king, and they substituted in the name of Massachusetts Bay in New England.
Perhaps I should say something about the other state constitutions, because I think it's against them that Massachusetts can be best understood, because it is a change of mind, second thoughts that enter into what was at the time regarded a conservative constitution, the Massachusetts Constitution of 1780. The Massachusetts people were fortunate in some sense, many would say, certainly Adams said that they delayed their constitution making. The other constitutions were quite radical, varying degrees of radicalism. They took the governor's powers, prerogative powers that the crown had to rule, and they just simply took them away from the governors, including the power to appoint officers, judicial officers as well as other civil officers. Power of patronage was regarded as a source of evil in England, and the Americans are not going to have any part of that in their governors. In fact, the governors became, as Jefferson put it, mere administrators. They lost the power to veto legislation. They had no role whatsoever in lawmaking. They even, in some states, lost the power to pardon, which would be essentially magisterial power, you would think, but it was given to the legislatures. So the governors are terribly weakened. They're annually elected in every case, but in every case in 76 by the legislatures. And in all of the states except two, Georgia and Pennsylvania, they created bicameral legislatures, more or less in emulation of their previous constitutions and in emulation of the English Constitution, which had this balance between a crown, a House of Lords, and a House of Commons. In some sense, the Americans were trying to republicanize, make republican this monarchical mixed constitution, and very much influenced, of course, by John Adams' little pamphlet called Thoughts on Government. But those are the principal characteristics of those early constitutions.
Professor Maier, didn't the early constitutions put tremendous weight, and even in our state with the early constitution, in the legislature the voice of the people, and obviously we're very suspicious of the governor as a representative of the king.
Yeah, that's true, but it makes tremendous sense if you think of it against the background of the colonial period, where the upper houses of the legislatures were normally appointed by the crown. Massachusetts was an exception here. So in most royal colonies, and most of the colonies were royal colonies, the only agency of provincial government that spoke for the people was the lower house of the legislature. So if you're asked what part of government from your experience do you trust the most, the answer was obviously the lower house of the legislature. So it may look to us particularly dramatic and radical that the first constitutions gave preference to the legislatures, but it seems to me this follows very naturally out of their previous history, and that it took a while for them to understand that a governor could also reflect the people in the same way the legislature did.
Well, Bill, at first, I mean, no chief executive would be trusted, given the war that they were in.
Well, it's interesting because we actually, of course, had two constitutions, the draft one of 78 and then the final one of 80. And Gordon's quite right about the radicalism of the early constitutions. And curiously, if you look at the Constitution, the draft of 1778, it in fact had the governor as a member of the state senate. And so in the 1778 draft constitution, there was this emphasis, as in the other colonies, other states, upon legislative power. And of course, the 1780, John Adams was adamantly opposed to that. He wanted a very powerful executive. In fact, he was disappointed that in the Constitution of 1780 that the legislature could override the governor's veto. He thought that the governor ought to have an absolute veto. As much as Adams celebrated legislative authority, he was very suspicious of legislatures, and in some curious ways there, he became far more enamored of executive power. I was just going to say one other quick thing, and a bit heretical perhaps in these precincts, but it does seem to me at times we view the Constitution of 1780 as springing from the head of John Adams in its total and complete form, somewhat like the head of Zeus. And what I think, and what I would urge citizens to look at, is not just what John Adams did, but quite remarkable when you read the returns of the towns. The level of political discussion going on in this Commonwealth in the time of the American Revolution does shame to us today. It was really quite, the grammar wasn't always good, and the spelling, you know, but nonetheless, I would love to have been present in the town of Hardwick, for example, and listen to the people of Hardwick debating these fundamental issues. So I think it's very important to remember that about our Constitution, that it wasn't just John Adams, but it was a wellspring of effort and discussion. We were lucky to be the last to write a state constitution because we had time to think about it.
Well, let's do that, but let's delay. I think we ought to talk about the Constitution of 1778 and some of the issues involved, and then move on to the Constitution of 79. But I have another kind of threshold basic question that I need an answer to. And Ahkil, could you talk about people's view of the British Constitution, which is an unwritten constitution, and then suddenly Americans are out there writing constitutions. How did we go, first of all, what did people view the British Constitution to be? And secondly, who bridged that gap from the unwritten British tradition to a written constitution that seems to be prevalent in all the colonies?
Well, there's 100 years or more of experience in America with written documents, charters. For example, Gordon mentioned the charters in Rhode Island and in Connecticut, the Charter of 1691 that's suspended, abrogated by the Coercive Acts. So Americans in several of the colonies, and it's the pride of some colonies that they have these written instruments. They begin in some places as actually almost corporate charters with an idea of kind of shareholders, and the shareholders become with some very clever moves on the part of early Americans, freemen, freeholders, and so Americans basically take control of these corporate charters from original investors in England and relocate power basically in the settlers. So you have a long American tradition, and then even places that don't have charters, you've got people forming churches and they covenant together, and they're on the and they're on a ship and they make a compact together.
So this is a natural evolution? This is not an idea from Adams or one of the great thinkers that said we shall have written constitutions? It's more of an evolutionary?
I want to agree with all my colleagues in basically talking about the fundamentally democratic experience. It's not one person. It's not John Adams in Philadelphia. It's not going to be James Madison. It's and a couple of other things about why the legislature is championed. More people can participate in it. Ordinary people who can't aspire to be governor can aspire maybe to be in the legislature and to serve on juries, actually, which would be the other great democratic institution that they inherit. So town meetings and juries and legislatures, and this is the voices of lots of ordinary people forming the backdrop.
Okay. Well, I think we've got, some of the groundwork.
Could I add
Sure,
something? I
please
think
do.
it's important to understand that at the outset, they knew that this Constitution that they wrote, and all of them wrote one, except for Connecticut and Rhode Island, should be fundamental law. But we take that for granted. They couldn't. And they struggled, really struggled over the next half dozen years. How do we make this Constitution fundamental law? And I'll give you an example of the struggling. Thomas Jefferson, as late as 1779, has written his statute for religious liberty, religious freedom in Virginia, something he cared deeply about. And he wants it to be more than a statute, but he doesn't know how to do that. And he says in the statute, it's really quite fascinating, his last line is, I know a subsequent legislature can pass a statute doing away with this statute, but if they do so, let them know that they'll be violating natural right. It's almost as if he's saying, look, I know I can't stop you from doing something to undo this action, but he puts a curse on them, so to speak. But he realizes that that's not effective. How do you make something like his statute for religious liberty, or the Constitution itself? He says the same thing about the Virginia Constitution. How do you make it fundamental? They're struggling with that. As late as 1779, he worries about how can I make it fundamental? And of course, the Massachusetts experience shows them how it can be done. You have to have the Constitution made by a body different from and superior to the ordinary legislature. And that seems simple to us, but it took them a lot of time, a half dozen years struggling with it.
Let's talk about that.
I want to go back toward Adam and Eve.
Sure.
I mean, when you asked Gordon to talk, I thought, oh, here's Thomas Prince all over again. What happened? I mean, where do you start? But we have skipped a sort of a year here from the time government fails in Massachusetts with the coercive acts, actually more than that, in the beginning of the war the next year, the total collapse of government, where Massachusetts does ask the Continental Congress what it should do, and it has Massachusetts resume government under its charter of 1691 as if the government was absent. But that starts a precedent. And other states, as the civil government collapsed, also asked the Continental Congress what they should do. So that the first constitutions that were written were actually before those very famous resolutions of May 1776. New Hampshire wrote a constitution, South Carolina in March 1776. And I remember coming across, while writing the book on the Declaration, William Henry Drayton, who was the Chief Justice in South Carolina. He convened the first court and talked about the wonder of the occasion. And in fact, what was interesting to me is that he thought as a prerogative of his position as a judge, he could declare South Carolina independent of Britain on good legal precedent, mind you, because everything that James II had been done by George III. But what was wonderful is the somehow the discovery that people made at that point, that governing themselves was the logical outcome. I mean, independence had never been people's ambition. They didn't fight this war so that they could take control of their own lives. They wanted to protect rights, and they basically backed into independence. But these statements that coming from localities, I mean, you get it in South Carolina, you find it in some of the wonderful local town statements of when the towns in Massachusetts were polled on the question of independence. How almost by surprise they discovered that the people best qualified to govern them was themselves. And it comes through as a surprise with a kind of a wonderment that's associated with it.
Well, let's see whether we can, in our teleconference, we talked about reading some of these, and we circulated some. I don't know whether anybody brought them.
But what you've got are the responses to later constitutions.
Yes, but
and
what
they're
I'm
a little
thinking
later.
is that if we move on chronologically, if we go to the Constitution of 1778,
Yeah.
my understanding of the sequence of events, and please correct me if I'm wrong, is the legislature petitioned the towns because it is still town government. They looked to the consent of the towns, and they said to the towns, shall we enact a constitution? And the towns came back with all of these returns, which are the returns that we circulated. Does anybody have it, willing to read any of those? Because I think they illustrate the point that Professor Wood first made, that the literacy of the people in the towns throughout Massachusetts, the farmers and people in breeches was remarkable. Shall I start with one, or?
Yeah, sure.
For instance, so this is a petition from Pittsfield in May of 1776. And correct me if I've got my dates wrong, but I think by then the legislature has petitioned the towns. Shall we enact a constitution? So Pittsfield says, what does it say? That the first step to be taken by a people in such a state of enjoyment or restoration of civil government amongst them is the formation of a fundamental constitution as the basis and groundwork for legislation. It's a constitution they're asking for. The appropriation of the majority of the people of this fundamental constitution is absolutely necessary to give life and to bring it. They're telling the legislature it's for the people to do. That then and not till then is the foundation laid for legislation. That's the point that you made. Who's making the Constitution? Is constitutional legislation or not? There's another one here from Suffolk County on religious and civil liberties. And if anybody else has these or wants to read others, feel free. The form of government, they basically say to form government and establish a constitution for the present and succeeding generations is a task or consideration the most important. It extends as much to our religious and civil liberties. They're essentially saying maybe we need a Bill of Rights here. Another one, separation of powers, which we attribute to the Constitution of 1780. This is from the instructions to the representatives of the town of Boston, back to the legislature. It is essential to the liberty that the legislative, judicial, and executive powers of government be, as nearly as possible, independent and separate from each other. For where they are united in the same persons, there will be wanting that natural check, which is the principal security against the enacting of arbitrary laws and a wanton exercise of power to execute them. It goes on. Adams is not yet, I mean, he's on the scene, but he's not yet drafting. We're still on the Constitution of 1778, and these are the towns responding in 1776. And they go on and on, but not all the towns are so well versed. Ashfield in Hampshire County, they're looking for a theocracy. Voted that it is our opinion that we do not want any governor but the governor of the universe, and under him a states general to consult. So they don't want. So it's bubbling up. But what happens? They Concord, I think, says that we should have a. Can you talk about Concord?
Well, Concord, like the Pittsfield people, says a legislature is inappropriate for drawing up a constitution, that legislatures draw up ordinary law. If they draft a constitution, then they'll feel free to change it, or as actually happened, to ignore it whenever it seemed to interfere with some project they had. Therefore, that whole process had to be taken out of the legislature, and that a special convention should be chosen to draft a constitution, and then it should be submitted back to the people. And they say for acceptance, rejection, or amendment, which is extremely interesting.
Right. And some towns wanted popular ratification. But, so this is the
Yes.
advice of the towns. Ahkil, did the legislature pay attention to that advice in 1776?
Not at first.
Said they passed a constitution and then...
They draft one up and send it back to the towns, and the towns say, among other things, what part of this of our earlier thing didn't you understand?
Right.
So they have both process and substantive objections, and the process objection was the very drafting of this by an ordinary government. And then there's substantive criticisms that they also have about the 1778 proposal. I've got one that I want to read at one point, but let's let others get in.
All right. So they submit this, it loses, I think, 5-1 or 6-1, is that right?
5-1.
5-1, and then there's there are all these returns or responses, why does it lose?
One of the most remarkable things, by the way, about the Constitution of 1778 was, in fact, the approval process. The legislature specifically said that all adult males could vote. There was no property qualification, that for whatever else they did wrong, and it was the first time in American history that a constitution was to be sent out for, at the time, virtually universal approval. All adult males could vote.
I think that's because they were groping to find some way of making this more fundamental
Yes,
than a statute.
I think you're
They
exactly
didn't
right.
take the step that they later take
Right.
and having a special body make it, but they are groping to somehow show that this is not an ordinary law.
But the earlier constitutions have been
Well, I suppose
groping
that
for it, too.
can be considered progress, but the Constitution, the proposed Constitution of 1778 also made it quite clear that slavery was acceptable and could continue in the Commonwealth, and that was one of the many reasons why I would suggest it was rejected, but it had a lot of problems.
One other thing, because I think it's very, very useful to get in our minds around the distinction between who can participate in and vote for and even serve in a convention about a constitution, who can vote on the ratification of the Constitution, and that's everyone, and then who gets to vote under the government that's going to be created, and they actually raise some, or they actually have some property qualification, and they have a race qualification in 1778, and some of the towns don't like it. And I want to read you one just because you hear democracy in action and also this wonderfully dry New England sense of humor. This is a particularly tart statement. It comes from Georgetown in 1778, May 25th, 1778. And they're responding to this race-based qualification for voting that authorized in the 1778 Constitution, rejected because, among other reasons, a man being born in Africa, India, or ancient American, or even being much sunburnt, deprived him of having a vote for representative.
Yep. And that town was not alone. Sort of to recap, the legislature asks opinion about to pass a constitution. A number of towns come back and say, no, it ought to be done by constitutional convention. There ought to be this. There ought to be separation of powers. The legislature ignores the dissenters. It passes a constitution, resubmits it to the people, and the people come back and say, no constitution. It needs a convention. It needs a Bill of Rights, which is what Judge Houston is talking about. And that whole issue I mean, there were other bills of rights, were there not, in other states?
Well, I
Were
think
they
in-
worried about
In
slavery?
1776, there were five, I think 5 of the states drafted bills of rights, but it wasn't at all clear in 1776 against whom the Bill of Rights would be directed. After all, the English Bill of Rights, as you know, was an act of Parliament. It's a statute. It's not directed against the House of Commons or the Parliament. It's directed against the King. So in 1776, it's not at all clear that their bills of rights are directed against the whole government, the legislature. You see, this is very important for understanding British history and our own, and this is where we separate. The British, all the acts of the Bill of Rights, the habeas corpus, all of that are statutes, not limiting the House of Commons or Parliament in any way. They limit only the Crown. Our Bill of Rights, as we know, the Federal Bill of Rights, limits the whole government. So that, how we get from one to the other is a very interesting story and not easily explained in a...
I just want to go back to the point we made earlier about the returns to the proposed Constitution of 1778, and read one section from one of the returns from the town of Sutton, which is in central Massachusetts. And central Massachusetts was a stronghold of abolition in the 19th century. But the town of Sutton submitted a return expressing its disapproval of the 1778 state constitution, particularly Article 5, which was characterized as, quote, wearing a very gross complexion of slavery. It was further suggested by the townspeople that it is diametrically repugnant to the grand and fundamental maxims of human rights, that law to bind all must be assented to by all. These are just average, everyday people who saw the weakness, the repugnance, if you will, of the 1778 proposal, and didn't hesitate to speak out. There wasn't a lot of it. A lot of the returns, as you mentioned, dealt more generally with concepts and rights and that sort of thing. But there were some that were quite emphatic about the failure of the Constitution of 78.
Before this, I saw several of you caucusing and asking sort of who was going to talk about the Essex result. So think about that for a second, because you have to talk about it. I'm from Newburyport. Theophilus Parsons, the author of the Essex result, is the first president of the Social Law Library, was a Chief Justice of the Supreme Judicial Court. But while you're cogitating on that, I have one other question about the Bill of Rights. I read something somewhere that the Bill of Rights was intended to protect the individuals against a magistrate. That was people's frames of mind. And with the early constitutions, where, as you said, they pushed down the authority, they dominated the chief executive, they didn't feel that they needed a Bill of Rights. And then over time, I mean, I don't react, it might be a nutty theory, I'm just throwing it out. I didn't make it up. That there became a more general distrust of government and maybe even the need for checks and balances for the legislature. Is there any does that make any sense?
John Adams in 1775, in his debate with Massachusettensis, who was Daniel Leonard, a Tory, a loyalist, Leonard had said to Adams, look, this Congress that you're creating can be tyrannical. It can be just as bad as the Crown, as you claim the Crown is tyrannical. And Adams says, that's crazy. It's illogical. The people cannot tyrannize against themselves. A democratic despotism, this is a quote, democratic despotism is a contradiction in terms. That's how Adams thought in 1775, as most Whigs did. The people can be trusted. Their representatives can be trusted. How can they commit tyranny? The Crown, through English history for centuries, has been the source of tyranny. The people can be trusted. By 1778 already, I think, around the states, there was a rethinking of that postulate, and people were realizing that the representatives of the people could indeed be tyrannical. And I think that's what led to an expanded notion of a Bill of Rights that would limit the whole government, not just the chief magistrate.
Do I have an...
Well, you know, you get the first important Bill of Rights before the Declaration of Independence, the Declaration of Rights in Virginia. And it has a rather curious history that the first draft, and the one that hit the press, was actually the draft by George Mason, who drafted the Constitution, was later in the Constitutional Convention, as amended by a committee, and it hit the American newspapers. Later, the Virginia Convention changed it to make modifications because some people said its declarations that all men are born equally free and independent raised some difficulties for a slave society. So they modified it to say all men are by nature equally free and independent, and they had certain rights which they couldn't yield when they entered a state of society. Now that's a lot of what in the 18th century we would have called Jesuitical language. I mean, basically they were not denying that blacks or slaves had rights, that they were anything but men, but it got the state of Virginia off the hook. But the original draft actually became the basis for the Pennsylvania Declaration of Rights, and I believe it was Pennsylvania that John Adams was looking at in drafting the Massachusetts Declaration of Rights. So much of that language is continued over, and this powerfully important language that all men are equal and independent, are born equal and independent, is extraordinarily important. It becomes the basis, of course, the court decisions in Massachusetts that emancipate Mumbet and Quock Walker in the 1780s. But it comes by a clear lineage. Are they talking about individual rights? Well, that certainly was used to defend individual rights, but I think an awful lot of these traditional rights were those of a community in an English tradition against a potentially tyrannical government. The right of freedom of the press, the people have to be able to consult with each other, to assemble, to petition. These are joint rights, and I think they were often emphasized because they were much more traditional. Curiously, it's very hard to count how many states have declarations of rights. I've discovered how difficult this is because there were some wonderful debates in the Pennsylvania Ratifying Convention I've been looking at where somebody said, James Wilson, a very distinguished jurist, says, Virginia doesn't have one. And this little yokel from Western Pennsylvania said, well, Mr. Mason tells me it does. But there was a book published of constitutions, and the Virginia Declaration of Rights didn't appear because it had been passed earlier by the legislature and wasn't attached formally to the Constitution. Well, there are a lot of other declarations that were passed by legislatures. We now know, for example, that New York passed an act concerning the rights of the citizens of this state in, I think, January or February 1787. Why? Well, they were worried to death about the federal government, which looked horrendously dangerous if it was about to get the power to raise taxes through the impost. Interestingly, they emphasize juridical rights, as if they were afraid the central government was going to oppress people through the court system, which is very interesting in modern circumstances.
Well, do we have any takers to talk before I want to move? We want to keep it moving and have enough time for questions and answers. But I understand talking about the Essex result is like talking about the rule of perpetuities for lawyers. Most people can't cite it after they go to law school. At least I can't. Bill, do you have? We have to talk about it because Chief Justice Armstrong is from Byfield, and I have a good friend here from Byfield. And if we don't talk about it a little bit, I'll be in trouble. Isn't it the most important statement against the Constitution of 1778?
The meeting of the Essex towns in Ipswich regarding the Constitution of 1778 is, I think, the pivotal moment in the formation of the Constitution of 1780. Because it is there in Ipswich that these representatives from the towns articulate most of the objections that all of the towns have. And of course, these were summarized by Theophilus Parsons, who you've already introduced, who in his own time apparently was known as Awfulist Parsons. But in any case, the Essex result runs, the printed document, runs for more than 50 pages. And it is an extraordinary document, and I recommend it to everyone. The beginning of the document is a summation of natural rights and history. It's a very philosophical treatise that sets a standard for government. And then, having set the standard for government, they then go into an indictment of why the Constitution of 1778 does not meet all of these requirements. And they go at it a very logical kind of way. There are some interesting questions that come up that still sort of prevail in our own time. Here in Massachusetts, is it the individuals or the towns? Is it individuals or corporate entities that are to vote and are to rule? And there was that discussion. It's a very important issue in the apportionment of representatives. Does each town get a representative, or are representatives by population? A problem, by the way, that persists and is not solved very well. The issue of the Bill of Rights is clear. They're absolutely clear on that. There must be a Bill of Rights. They condemn slavery, that slavery is to be condemned. They're also very strong on the separation of powers, which was very mushy in the 78 Constitution. There must be a clear separation of powers. The governor cannot be a member of the state senate. Judges must be appointed by the executive, not elected by the legislature, but appointed by the executive and serve for a term of good behavior. Must be a convention called specifically. And the expression that comes up repeatedly in this document, consent of the governed. Consent of the governed. They are adamantly committed that no law can be passed. You are not bound by any law unless it is by your consent. And they bring that up again and again and again. Again, I think emphasizing what's already been emphasized, their concern that this is the fundamental law. They also had a sense that if this Constitution was not to last forever, it was to last for something close to forever. Think for a moment, 1778 is a bad time in America. We're losing the revolution. The French alliance has barely come on. The British are ransacking our coast. New York is in their possession. They have Savannah. They're closing in on China. It's not a good time, which to me, by the way, is an extraordinary testimony to their faith, that in the middle of a war they were losing, they were going to establish independent governments. So a rather interesting article of faith. But the expression that they said in the Essex result was that the Constitution should, quote, survive the rude storms of time. Survive the rude storms of time. So no matter how bad things were now, they were writing a document that should prevail, if not forever, for a very long time.
And
Yep.
the Essex result was authored by a 27-year-old lawyer named Theophilus Parsons, who was later to become Chief Justice of the Supreme Judicial Court.
Right. Okay. So where are we? We have the legislature has passed the Constitution of 1778. The towns have gone 5-1. The legislature gets the lesson, and maybe this is a lesson in history where if at first you don't succeed, try again. And then the legislature re-petitions the towns and says, shall we try again? And this time, shall we have a convention? And the answer is a resounding yes. So Bill was talking about the Essex result, consent. Can someone talk about the importance of the convention? Is this the first time there was a convention ever they figured out that there's a difference between fundamental law and enactment. You need a convention for fundamental law. So help me out
Convention's
there.
an old word in English history. I mean, usually it was a parliament that was defective in some way, like the Convention Parliament of 1688-89. The king was gone, so it wasn't completely legal. I think that's the sense in which the conventions, and Gordon could correct me, in Pennsylvania and Delaware that drafted constitutions, I think they were in that older sense. They were really legislatures, but understood to be not completely legal.
The
kind of-
legally deficient legislatures
Yeah.
are the conventions and congresses of the, because the chief magistrate's not present. It's just as if the king is
Right.
not present. And that, of course, is what happened in 1688. King James II flees, so the parliament has to come together, but they aren't legally a parliament, so they're just a convention. But and they have a declaration of rights. But once King William comes back, or
It's
is brought
parliament
in
again.
as king, then they become a parliament, and
Right.
suddenly they pass the Bill of Rights, which is just, in other words, showing that the parliament is superior to this convention. And that occurred later with Vermont, for example. They had a convention that drew up their constitution, but once they became a real government, they had the legislature pass the constitution.
So what that means is that the use of the word Massachusetts was novel, and that is they were using it for, in a sense that is familiar to us, because they were beginning the whole creation of constitutional conventions. That is a body elected for one job and one job only, and it was a legitimate legal institution to draft a constitution which would then be submitted to the people for ratification. And that became an institution, American constitutionalism, of a sort that didn't exist before. So this is the first constitutional convention in the modern sense, as a body with a distinct task that is not simply a deficient legislature.
And it's one of the great inventions of
the
world
American
politics,
Revolution, yeah.
institution.
And eventually there'll be a distinction between a proposing convention, which you just heard about, and a ratifying convention. So at the federal model, we have a Philadelphia proposing convention and then 13 state ratifying conventions. Those separating functions that in Pennsylvania in 1776, for example, I'm pointing to Pauline because she's written about that in particular. Actually, everyone here, I'm sure Gordon has to, but there you had the same body proposing in effect and ratifying. in
So
this
they're not
irregular-
enacting, and it is again, of the people, we the people, that kind of idea, where the people come
They're
together to...
elected by the people to draft a proposal which will be submitted back to the people. With one little exception, which I didn't really understand about Massachusetts, but Ahkil directed me to a wonderful study by Samuel Eliot Morris in 1916-17, Proceedings of the Massachusetts Historical Society. Apparently what the convention did was to submit it to the people, and then it reconvened later to look over the results, and the returns, and they demanded a two-thirds vote. And it isn't altogether clear that it got a two-thirds vote, but it was declared ratified, and he has this very affecting statement. He leaves it to the readers to decide whether or not the Massachusetts Constitution of 1780 was ever ratified.
And it's because these towns, some of them say it's all fine by us, and others of the towns say, we like these provisions, but we have problems with these, and it's not even clear what problems means. And then others say, we reject the following articles, but how do you tally that given that they've accepted the others, and so how do you aggregate all these returns? Because it wasn't clear from the beginning that the towns were simply to vote up, down on the whole thing.
Right.
But I think it's important to emphasize just how important this idea of a convention was, because Jefferson, once he saw what happened, between 1779, as I said, he had no idea how do you make a constitution, and by the time he comes to write his notes on the state of Virginia, he has an answer, and he draws directly from this Massachusetts experience. And of course, ever since, states have used constitutional conventions. I think we can't emphasize the importance of that enough.
Bill?
While I certainly share my colleagues' enthusiasm for conventions, there's a bit of caution I would urge here. The Massachusetts Convention in 1779 was, I think, hardly a democratic exercise. When you look at what really happened, the kind of way the sausages really were made, when you look at the proceedings of the convention, you realize that we go from a rather high attendance to almost no one coming. In the end, in fact, there's barely, no one ever calls for the quorum, I suspect. John Adams does indeed write most of it, not all of it. Some of it's changed. And then there is this wonderful dramatic moment at the very end of the convention. They have a very complicated ratifying process in the towns that even after 200 years, no one really understands. The returns come back from the towns. They give it to a committee of 5 people. 5 people work on this for about 3 or 4 days, and they can't figure it out. So what do? Enlarge the committee. So they went from 5 to 32. So now there's a committee of 32 reviewing the returns. They really can't make sense of this either. And so comes the dramatic moment. There are 98 articles in the Constitution. In the convention, they read each one. Article 1, approved, approved. Article, and this goes on. There is no discussion, and no one is looking terribly closely at the returns because, indeed, as Morrison pointed out, and if you'd like to go over to Columbia Point, to the State Archives, it's worth the trip to look at the original returns. And even reading them today, you realize that there's a fair amount of confusion here. And so there are certain articles of the Constitution, Article 3 in particular, the one having to deal with the support of religion, which seems pretty certain it wasn't approved. But the convention, at this moment, having sat long, the weather was getting colder, it was getting darker, they simply wanted to approve this. And interestingly enough, when you go back to the towns after the approval, after the convention has ratified this Constitution, you realize, in looking at some of the towns, that they too, in the communities, sort of understood that not everything had quite gone precisely the way it was stipulated, but no one questioned it. No one questioned it. Again, the midst of a revolution, 1780, not a good time to be in confusion.
And once you understand the fundamentally experimental nature, the innovation, that this thing hadn't quite ever been done that way, you'd expect, actually, they'd see some glitches as they're doing it, as opposed to jury trial, which they've been running for a very long time in Massachusetts. One other point about this convention, not only in the towns was there basically universal free male suffrage on the ratification, but eligibility for this drafting convention was also wide open. No property qualifications at all, even as the 1780 Constitution itself raises property qualifications compared to the colonial baseline for ordinary elections. So liberal and conservative in ways, raising property qualifications for ordinary elections, but in a process in which everyone was eligible to serve as a delegate in the drafting, and everyone, by everyone, that's in 1780 terms, there are lots of people that aren't counted, but universal free male suffrage, no race qualification, no property qualification. Everyone eligible to serve in the conventions as well as in the town meetings.
There were 312 delegates practically from every town. Bill and I were talking on the phone the other day, about the freakishness of weather. And the winter of 1779 to 1780 apparently had been the severest winter in 70 years. It got so bad, I guess, the troops with General Washington that spring wanted to mutiny and other things. The net result, as we were talking about, is that the conventioners from the western part of the state, those people who were much more liberal, those people that did not want life tenure for judges, they preferred an elected judiciary. Those people that preferred, if I understand it, a unicameral legislature, kind of the people, they didn't show up because of the weather. And Bill, is that your reading of
Yes,
history
it is.
too?
And in fact, that the Westerners were so poorly represented in the end, in the convention that finally ratified the document, comes back to haunt the Commonwealth in 1785 with Shays' rebellion. Because you realize in some of the literature and pamphlets and in the town meetings that indeed this does come up. The sort of, well, we weren't there in 1779, 1780, and therefore we don't feel as attached to this Eastern Constitution as you do. And it does come back to sort of haunt the legitimacy of the 1780 Constitution as far as the Western view went.
And it connects to your earlier point about apportionment. Do we think about this in corporate terms or one person, one vote terms? Because from another perspective, the West is sort of, by modern one person, one vote standards, overrepresented in some ways given apportionment formula.
One of the little footnotes that I'd share with you is that if you do the mathematics, for the 1780 Constitution and follow the apportionment and the representation for the House, by the early 19th century, the House of Representatives numbered over 600.
There you go.
600 never came, you understand. But theoretically, if one followed the letter of the law of the Constitution of 1780, by the early 19th century, there were 600-plus people eligible to sit in the House.
I should say, we haven't talked about John Adams much yet, but this document, whether they were counting Chads or not, and the 19th century version, was drafted by a committee. There were 312 delegates that narrowed into a smaller committee of, I think, 20 or 30 people from around the state. And they needed statewide representation because of the failure of the Constitution of 1778. Had they not had that legitimacy, it wouldn't have worked. That narrowed down to a panel of 3 people, Bowdoin, Adams, Samuel Adams, and John Adams. And John Adams becomes the principal drafter of this Constitution, which was ratified. I'd like to now just kind of talk about the Constitution itself, look at the basic structure, and then maybe look at some of the highlights. It's a long document. We can't talk about everything, but there are certainly some things that are worthy of review. It starts with a Declaration of Independence, which, of course, the federal Constitution doesn't have. And in that Declaration of Independence, Julian, you and I looked at it, and it has, what does it include? It has all of those commonplace things that we're used to. Freedom of freedom of it has the protection of rights, individual rights.
Declaration of Rights.
Freedom of speech, freedom of press, freedom of religion, right to assembly. We can't talk about all of these, but it has all of those before the federal Constitution. Ahkil, did the inclusion, or anyone here, Pauline, did the inclusion of those rights which we take for granted and associate with our Bill of Rights, did they have any influence on the federal Constitution or the adoption of the federal Bill?
Are you talking about the Massachusetts Constitution of 1780?
Yes, the Constitution of 1780.
It doesn't start with the Declaration of Independence.
With a preamble.
Uh,
You're right, it starts with the preamble.
Starts with the preamble, but the preamble states beautifully the whole theory of government that these procedures are meant to realize. There's a big mystery. Certainly it was mysterious to the Crown why the Americans in the 1760s were condemning acts of Parliament as unconstitutional. It didn't make any sense. The British Constitution was basically the system of all the laws, court decisions, customs by which England was governed. So how could an act of Parliament be unconstitutional? It was idiotic. I mean, from their perspective, these provincials didn't understand anything. But the colonists had these ideas in their head that a constitution should be written, which the British Constitution wasn't, but that many of their provincial they had an experience of written documents which outlined their governments and therefore limited power. But they also had an idea of a kind of a social compact that didn't exist. But now it was basically realized in the Massachusetts Constitution, which says the body politic is formed by a voluntary association of individuals. It is a social compact by which the whole people covenants with each citizen and each citizen with the whole people, that all shall be governed by certain laws for the common good, ... We, therefore, the people of Massachusetts, ... do agree upon, ordain, and establish the following Declaration of Rights and Frame of Government as the Constitution of the Commonwealth of Massachusetts. So words are very familiar because they were picked up in a rather truncated version and plugged into the federal Constitution.
That is, we the people?
We the people, right, do ordain and establish. But the theory is laid out in the Massachusetts Constitution. So it's extraordinarily influential in that way. With regard to the Declaration of Rights, I mean, this is what people thought of as a Declaration of Rights. What we got on the federal level was a very truncated version. And Ahkil has written very eloquently that certainly the courts weren't even in agreement, or indeed the federal courts through the greater part of the first century didn't consider the first 10 amendments to the federal Constitution as a bill or declaration of rights. To me, it's a question whether people at the time used that language in the 1790s, and I intend to find out, but I don't really know at this point.
And it'll be in your next book, and you'll come here and talk about it when you
It
do.
will, and I will do that. But this is, the Declaration of Rights here is much fuller. Now, there are problems with it, that they use language that's based on English precedent. You know, certain rights ought to be respected. This is an older language, and in time they tend to be much more forthright, of course. But it's a much fuller statement of rights, and in fact, this tends to be the situation. Certainly, it is in New York and in Massachusetts. That often the state declarations or bills of rights protect individuals' rights much better than the federal Bill of Rights, which, of course, wasn't of much importance for 150 years anyway.
Did you have a say? I just want to drive one point home out of a matter of state pride here. Is that phrase, "we therefore the people," is that what the drafters of the federal Constitution looked to? They just took out the "therefore" and came up with "we the people" as the first inspirational words of the federal Constitution? Is it shown up anywhere else?
The obvious precedent.
It's a blend of really two. The people who basically give us that language in Philadelphia are two Pennsylvanians, James Wilson and Gouverneur Morris, although Morris also is a New Yorker when he wants to be. Here's 1776 in Pennsylvania. You don't have the same exact words about people, but you do have some other language. "We, the representatives of the freemen of Pennsylvania, to promote the general happiness of this people and their posterity, do ordain, declare, and establish the following Constitution of the
It's all the
Commonwealth."
difference in the world. We, the representatives of people, or we, the people.
So says a Massachusetts person.
So when you say that there's a state, that they believe that there is a state of nature, and this is a genuine, honest-to-goodness, no-nonsense social compact, you have it done with a constitutional convention, the representatives of which it could be anyone.
But here's the biggest thing. Forget the text for just a moment. Pennsylvania does it a different way, too. They have a convention that basically meets, and it expands the suffrage compared to the colonial era by 50 to 90%, according to Pauline's estimate. So it's, again, more of a populist act than things that it done before, but not with a separate ratification. So Pennsylvania is groping toward this. Massachusetts takes it the next step. So it's not just what they say, "we the people," it's what they do. They actually put this thing to a vote. It loses the first time. It kind of wins the second time, close enough, in a war and good enough for government work. And that is the model for the federal thing. They don't just say it, they do it. We, the people, do ordain and establish. And here's the one thing to remember. And in the meantime, the one state copies the Massachusetts experience, and that's your neighbors in New Hampshire. And they actually the Constitution actually in New Hampshire gets adopted the fourth time through. 3 different times it fails, and finally. So here's the track record. Just fast forward, since you asked a little bit about how it foreshadows the federal experience and the Federal Bill of Rights and all the rest, which talks about the rights of the people to assemble in places like conventions for purposes like constitutional change and creation. But here's the track record that the Philadelphians have when they're proposing this. There have only been 2 states that have really put it to anything like a popular vote, their proposed state constitutions. Massachusetts, 1778 and 1780, and New Hampshire. Here's the track record that you have going in. 6 proposals, 2 ratifications. Those are your odds, when the Philadelphians propose their version. They're not at all guaranteed that it's going to go through, and in fact, it passes in close ways, not altogether dissimilar from the Massachusetts experience.
Of course, the crucial change in the Philadelphia Convention, and Ahkil has just written about this, is when the first draft, it says, "We the people of Massachusetts, New Hampshire, Maryland," and so on. And they eliminate, I think it's Gouverneur Morris, who just throws those states out. You can imagine the change in our history from that omission, what that meant, eliminating those states from the preamble of the Constitution made all the difference.
And part of it, which is connected to what we've just been talking about, is it's extremely awkward if you list all 13 states before you know whether any of them has ratified. And the Constitution is actually going to say only 9 are necessary for it to go into operation, and you don't know which 9 there might be. When Washington is elected president, just so we're clear, there are only 11 states that have said yes. Rhode Island has not said yes, and North Carolina has not yet said yes. So it's rather awkward if you list all 13 in the first sentence of your new document, unless you're sure that all 13 are going to come aboard, and eventually they do.
That may have been the reason they eliminated the states, not foreseeing how important it would be in the end.
Yeah, I just want to say, first of all, I'm sitting here listening to these historians discuss the language in our Constitution, and for me, and I hope for everybody else, it's just wonderful to hear. On a practical level, as a judge, while there is certainly not an identity between the Declaration of Rights and the Bill of Rights of the Constitution of the United States, I've always been struck by the extent to which lawyers who were making constitutional claims omitted the Declaration of Rights where that could provide additional support for their claim. I mean, it seems elementary to me, and I think it's probably done more now as a result of the position of the Supreme Court of the United States on giving more credence to state courts, state decisions. But, well, that's all I'll say for now.
That's a fault of law schools, largely. National law schools that take people from 50 states, don't teach them very much about state law, but lowest common denominator, federal constitutional law, and then they become the lawyers and the judges, and they haven't learned as much, having gone to these national law schools, about their individual state experiences.
I want to talk some more about some of the specific provisions, checks and balances. John Adams built into it this notion of separation of powers in Article 30. May it be a government of laws and not of men. Is that the first time that whenever anybody is indicted, somebody is going to say this is a government of laws and not of men. And is the genesis of that phrase the Constitution of 1780? Is it found anywhere else? Is it ours?
Adams uses the phrase much earlier in his career, but I can't put my finger on it.
Well, he's
exactly.
ours.
Right, but I'm sure it's widely, you can probably find something similar.
I think, Bob, the interesting thing to me about Article 30 is clearly the notion of separation of powers has been around for a long time. But it's stated in such a vehement way in Article 30. There's no, it's not just we shall have a separation of powers, but it's really very, very explicit.
And apart from that declaration, the Massachusetts Constitution is, I think, distinctive in having separate chapters, separate articles for the separate branches. That wasn't actually what you see in the not so tidily organized predecessor state constitution. So one of the many respects in which the federal Constitution mimics the Massachusetts, the language of the preamble, the doing of the ordainment and establishment in this two-step, two-convention model that was especially populist, but yet another one, 3 articles in a certain order for 3 branches. That is Massachusetts 1780 and not the predecessor documents.
But isn't it interesting that under the frame of government there's one chapter that deals with the executive and another chapter that deals with the legislature and another chapter that deals with the judiciary.
Yeah.
But the strongest wording about separation of powers and independence of the judiciary is in Article 30 of the Declaration of Rights. Then it is saying that the judiciary, like Judge Kaplan said, the mighty invention of an independent judiciary. Let's talk about the independence of the judiciary.
Well,
Under the Declaration of Rights. It seems like a funny place to put
what's
it.
extraordinary about this Constitution is this, in the address, which was sent out by the convention as a kind of their preamble to what they're doing. They said there are 3 capital powers of government. Now, that's the first time I've seen that phrase. It's picked up and used that way by Madison and others. What the branch of government that benefits most from this new articulation of separation of powers is the judiciary. In fact, you go back to 1775, 76, and Adams is talking about there are only 2 powers in government. There's the magistrate, the chief magistrate, and the lesser magistrates, and there's the legislature. In other words, there are only really 2 powers. What happens in the decade following the Declaration is the emergence of the judiciary as an equal to the other 2 powers. And that is really the most, in my mind, the most extraordinary constitutional development of the period. And as I've said many times, there's no book on this subject of the growth of an independent judiciary. The judiciary, the judges, have become equal, so to speak, alongside. That shows up in the structure of the Constitution, giving them a separate section, just as the federal Constitution does, Section 3, as an equal partner with these other 2 powers. I think this is really quite remarkable.
And you still see the residue of its earlier inferiority. It's always listed, it's listed in Massachusetts and the federal, 3rd out of 3. There's less text devoted to it than to the other 2 branches in both the Massachusetts and the federal Constitution. And the basic structure, might be a violation of separation of a certain sort, but there's a pyramid structure in which the legislature and the executive pick the judges, but the judges, you see, don't pick the legislature and executive, or at least they didn't before a case called Bush versus Gore. You see, legislatures, for example, pick their own leaders. Judges don't pick their own leaders. They don't even get to pick their chief judge. Legislature, the executive gets to pick, in the federal model, not in the Massachusetts model, but he gets to pick his cabinet officers and his subordinates. But Chief Justice Marshall doesn't get to pick her lieutenants on the lower court. So even in these constitutions, it's being brought up on a level with the others, but you still see it as the weak. The weakest, the least dangerous branch to borrow from Hamilton. And here's one big reason why. Again, I think history provides a clue. The judge in 1775-76, in 10 of the 13 colonies, the chief judge sides with George III against George Washington. These guys are basically crown types. If you put aside 2 states, Rhode Island and Connecticut, which is largely self-governing, where because they have these charters, the people are actually picking their judges. You put aside those 2 states, of the 50 signers of the Declaration of Independence, I think only 3 have significant judicial experience. They like juries a lot more than judges because they're sort of patriots, and judges in most of the states are loyalists.
Well, to add to Ahkil's point, the judges are conservative during good behavior, but they can be removed by an address of the legislature, which of course is what could be done in England. Even though the Act of Settlement gave them protection against the Crown, it didn't protect them against the House of Commons and the House of Lords. So that is written into this 1780 Constitution. They can be removed from a simple address of the majority address of the legislature. In this sense, the federal Constitution gives an added protection to judges. Although John Randolph always argued that it was implicit that they could be removed. He didn't get away with that.
There is an interesting hole in the wall between the legislative and the judiciary in our Constitution, though. And it was something that was debated, and that is the business about seeking an advisory opinion.
Oh, yeah.
And that, indeed, is a hole in this separation. And in the convention, there was debate about that it was an inappropriate intrusion on the part of the judiciary into the legislative process, that the legislature ought not to have the opportunity, that the judges not to be completely separate. I don't know if that's unique in our Constitution, that is the advisory opinion, but it certainly was under debate at the time and was seen as an overlapping of these 2 jurisdictions.
And several modern state constitutions have advisory opinions. I don't know if any of the early state constitutions. Remember also one thing, which is that the judiciary is, I think, best understood as including not just the judges but juries, as a kind of lower house, bicameral judiciary. And in something like the Kwok, Walker, and Holmes versus Jennison cases about the ultimate abolition of slavery in Massachusetts, it's not just the judges like Cushing and others doing this. They were doing this in jury trials, very much moving in sync with evolving custom in Massachusetts, as embodied very much in a series of sort of jury verdicts in favor of slaves basically walking away and freeing themselves in effect. And so it's judges and juries working together in some important sense.
We have about a half an hour, and I'm wondering whether you want us to go on, or do people have questions? I do want to ask two more basic questions of the panel, and that is, one, what was the influence and the response to the Massachusetts Constitution of 1780, both with the federal Constitution, and what was the role ultimately, what's your verdict of history, if you will, of the influence of John Adams on this Constitution, on constitutionalism? We cannot escape that question and let it go. And then I think we'll open it up, to questions. And if there are no questions, we'll keep talking.
Well, the great irony, on John Adams, irony is that he was probably, with, I would guess, George Mason, one of the leading writers of constitutions of that early period of American constitutionalism. But of course, he got swept away into the diplomatic world and wasn't here by in 1787. So his influence on the process came through what he put into the Massachusetts Constitution. And I think the influence is substantial. I mean, Ahkil has pointed to the fact that there are 3 parts. I mean, if you look at some of the earlier constitutions, they look like a jumble.
They do.
They're just lists of propositions, almost unordered, as they came to the mind of the drafters. They wrote them down and they never rearranged them. They didn't have nice, easy computers where you could cut and paste to put them in a nice logical order. Or they're numbered provisions, which have almost the same chaotic quality. This is a very ordered constitution. Part 1 is the Declaration of Rights. Part 2 is the frame of government. Chapter 1 of the frame of government is the legislative. Chapter 2 is the executive. Chapter 3 is the judiciary. Sounds familiar. The only thing that's different is, of course, that the federal Constitution didn't have a part the first, which was the Declaration of Rights, and that was a mistake. This is much more logical. If the Statement of Rights is to be an assertion of those rights that government were formed to protect, if there are to be limits on authority, they should be listed in the beginning, as George Mason would have done with the federal Constitution, not pinned at the end like the afterthought they were on the federal Constitution. He didn't have quite influence enough, but his influence was substantial.
Well, did he have another kind of influence in terms of this Constitution? That is, he protected the rights, he established a frame of government with co-equal branches, separation of powers, but I don't remember what sections, but there were some value issues here. Didn't he believe that government had a responsibility? He was a liberal, I suppose, in one sense, had a responsibility, to help that university in Cambridge, that is education, and he was also interested in the establishment of religion. And can someone, I've always been a little confused about that. There's a great debate about the religion. He provided for the establishment of a religion, I guess the Congregationalists, with taxes on one hand, and on the other hand had very eloquent language to provide freedom of religion. Someone help me out here.
Just a quick comment on the provisions about Harvard. They were written by Harvard. I mean that literally, that there was in fact a committee, the overseers, the corporation, whatever the structure was, that actually wrote what is in our state constitution about Harvard, and then of course they sent it across the street to where the convention was meeting over at the First Church. So Adams, while he certainly might have approved of that, he didn't write it. One of the good things, though, by the way, that according to our state constitution, professors at Harvard are forbidden to run for the House or the Senate, and that may please some people. I just want to make a comment about John Adams's role, which clearly was monumental. There's no question about that. But it does trouble me a little bit when we begin to talk in those terms. Because if we do say that, and if we elevate Mr. Adams to perhaps the place where he ought to be, it forces us to denigrate or to ignore the environment in which he worked. If Adams was as great and as influential, et cetera, as we would like to believe sometimes, then it might follow that all we need to do is find a John Adams and send him to Baghdad. But we know that, and so again, I think it's very important to keep in mind that Adams was in many ways the expression of his times.
Right.
I don't mean he was a mouthpiece, but he was clearly the expression of the right man at the right time. But we need to be a little cautious, I think, as we elevate him to the priesthood.
There's one funny response from the return of Springfield, which I thought was worth reading. He said, the people of Springfield may be justly fearful that at some future time, less virtuous than the present, and they go on to explain why they want more safeguards. The one thing we might say about Adams is we haven't talked about at all, and it's the thing he's most concerned about. When he talked about balanced government, he wasn't talking about what we mean by separation of powers, legislative, judiciary, and executive. He meant a bicameral legislature with a governor who had an absolute veto. Now, his model was the English Constitution, and this is what I think is really innovative about this veto that ended up. The whole idea about the king's role was that he was assenting to legislation. He's assenting to law. It isn't that he has a veto. If he doesn't assent, that's in effect a veto, but he has a role in legislation. Now, what happens here in the Massachusetts, that's what Adams thought. He thought the governor should be like the estate of the crown. The three estates of the realm should have a role in legislation. But the convention threw it out. And they instead say this legislature is made up of two branches, one of which represents people, the other property, and the governor is separated. However, the governor is allowed to veto legislation. That is to say, he can assent to the laws temporarily, and the legislature can overrule them. That's all new. There's no other state that has that. That's completely an innovation, and it changes the role completely of the governor. Instead of assenting to legislation, instead of being a legislator, as the King of England is, he becomes a kind of another power checking the legislature.
And that was the convention. It wasn't Adams.
Right,
who did
and it's
that.
a completely different way of looking at in fact, the term veto, which we take for granted, but it comes out of a very, very different kind of circumstances from what Adams had in mind.
And the vetoes were expected to be typically on constitutional grounds. I think there are 3 vetoes between 1780 and 1787, and 2 of them are explicitly constitutional. One of them is about the governor's salary, I believe, or maybe 2 of them are about the governor's salary. Very prickly about that. And so what we think of as judicial review, that's very important, but they had an idea kind of executive review, that the governors would, and later presidents, would veto bills on constitutional grounds if they offended constitutional principles. And ironically, actually, had Adams prevailed, it might have been, as a practical matter, more difficult for governors in the future. If they actually had an absolute veto, they might have hesitated to use it, as kings of England, in fact, had hesitated to use the royal veto after about 1707 or so. But the very fact of its overrideability in some ways makes it a power that's more likely sometimes to be used, because one man isn't imposing his will on all of his fellow citizens. There actually is a way of overriding that. And so it actually, in some ways, I think, is more powerful when modified, when reduced.
So that really supports Bill's extraordinarily good point, that we have a tendency to reduce these great achievements to their simplest terms. That is, the Massachusetts Constitution is the work of John Adams. The Declaration of Independence was the contribution of Thomas Jefferson, and the federal Constitution is the work of James Madison. Madison, to his credit, had the decency to say it was untrue, that it was the work of many hands. In truth, as I have argued with the Declaration of Independence, they were all the work of many hands.
Yes.
And the Massachusetts Constitution is the clearest example. If you look at those town returns, it really was the product of a massive popular debate about the character and the form of government.
Well,
Yeah.
I've asked a lot of questions, and I would like to throw it out to the floor to see whether, John Henn, please.
The federal constitutional analog to the Massachusetts Constitution would probably include the Bill of Rights, civil rights, the individual rights. So that leaves us with about 212 amendments left of the federal constitution, which is pretty long. This constitution, 120 amendments. So
Yeah.
this is so good. I think it's in the federal constitution, and 10 individual rights amendments. There's only 12 amendments in Geneva.
Maybe we've needed more, but you know, they're pretty hard to do in the federal constitution. Maybe a little too hard.
For those that couldn't hear the question, it was, why does the federal constitution have so few amendments and the state constitution have so many? And the answer is, Bill?
Well, I don't know if I have first off, the original Constitution had no provision for amendments. In the 1780 Constitution, there is no provision for making amendments. There was a provision that they would meet again, sort of, if two-thirds of the people wanted to, I think in 1790 or 95, which they didn't do. And then in 1820, I guess with the constitutional, you could only amend the Constitution if everybody gathered together again, which they did in 1820. And it was in 1820 that they provided for the legislative mechanism to amend the Constitution going out to the people, essentially what we do today. So our Constitution is frankly very easy to amend. And I think that's probably more than any other reason why it's been amended so many times. It is easy to amend.
Right. Mr. Mazmanian?
I'm impressed by the recent development you have. The point of the role of the Constitution with regard to religion. There's an establishment clause, is a highly type method, is perhaps a method of choice, but then there's a sense of required attendance at a religious institution. So this is before U.S. Constitution. The First Amendment anti-establishment clause only applies to the federal government. So only applies to the federal government. So what I'm wondering is what you have to say about the religious views of John Adams reflected in the Massachusetts Constitution and compare that with what was done with the U.S. Constitution a few years later.
A few quick points. One, in the preamble, you see in Massachusetts a more explicit and emphatic invocation of religion than in the federal preamble. One of the biggest things in the federal Constitution is what's not there, the kind of open references to God that you see in almost all the state constitutions. The only thing that there is the date clause in the year of our Lord. September 17, 1787. What's really important in the oath of office clause, the presidential oath of office clause in the federal model, is what's not there. The word "so help me God," which George Washington added as a personal touch, and others have adopted, but what was in many state constitutions, and there's a religious test in the Massachusetts Constitution for office holding, and you don't see that in the federal Constitution. And in fact, in the federal Constitution, you do see, even before the Bill of Rights, that there can't be a religious test imposed for any federal office, and that is not in any of the state constitutions. In 10 of the state constitutions, there are actually religious tests imposed by the state constitution itself, and in the 11th state, New York, has religious tests, but it's just by statute, and there are only 2 that don't have religious tests, and that's not because something in the Constitution says you can't have a religious test. So the federal model, if we're looking at sort of what's new, just like we asked what's new about the Massachusetts experience, and we've seen a lot, a new thing is a lot more freedom for people of all faiths and even for people of no faith. 2 of the 4 guys up there on Mount Rushmore are not members of any formal church when they're elected president of the United States, which is pretty striking. Now, there are a bunch of reasons for that. Here's one. There's a lot of religious diversity in America, And so the lowest common denominator is just the federal government will be hands-off, because they're Congregationalists up in New England, and they're Anglicans down south, and they're Quakers in Pennsylvania, and they're sort of Baptists throughout, and Massachusetts and Maryland is a Catholic stronghold. There's some Catholics also in Rhode Island and other places. So the First Amendment actually can be understood not just as anti-establishment, but as pro-states' rights. Congress shall make no law respecting, that is, on the topic of religion. And one thing that means is there won't be a national church, but it also means Congress will make no law disestablishing the Massachusetts state church. Congress basically has to keep its hands off. Massachusetts disestablishes in 1833, but the federal government has no enumerated power over this domain. It's almost 10th Amendment-like language. Congress shall make no law. This is just beyond the jurisdiction of the federal authorities, and in that respect, the federal model is a little bit like the a solution in Europe of curius regio eius religio. There won't be an empire-wide policy on religion. We're going to leave it up to local option in Central Europe. And so some places will be Protestant duchies and others will be Catholic fiefdoms, and there won't be an empire-wide policy. And in some ways, that's the American experience. There's more complete separation in Virginia. There's more union of government and religion in Massachusetts, and the feds basically say hands off.
Herb Gleason, wait for the mic. I have one question while it's going over. There's God is mentioned a lot in here, in this Constitution. Were the framers deists? I mean, you know, I think I read somewhere that Adam said he believed in reason more than revelation.
In defense of Adams, by the way, he did not write Article 3, the infamous Article 3 in the state constitution. Later in life, as he takes credit for nearly everything else, but Article 3 was something that he was always troubled by. I'm not suggesting that he might not have agreed, but it was, in fact, he said later that he never felt capable of actually writing that article. So he was in a quandary. He was a bit confused by it, but he did not write, he did not establish the church as it is in fact established in Article 3.
Okay. Herb Gleason?
None of you has pointed to a source of the idea that there should be an organic framework beyond the reach of the legislature. Is there such a source other than the unwritten English Constitution or British Constitution, which could, of course, be changed by Parliament?
I'm not sure I follow what you said. I thought that's what we've been talking about, how they stumbled and fumbled, but came up with a means of creating a distinction between the fundamental law of the Constitution and mere statute legislation. That was not easily arrived at. And that was original with them. Oh, it's very original with them. English don't have that. Didn't have it then and don't have it now. The legislature in England can suspend habeas corpus at its will, as it's done. Now, there is a crack opening in England, I should say, as judges invoking the conventions, the European conventions that England has signed, have begun appealing to those and are asserting a kind of judicial review. But by and large, this whole development is a peculiarly American development. And it really is happening in Massachusetts best in this very crucial period between 1776 and 1780.
Mr. Lewis?
You've just said again, as you all said before in this wonderfully eloquent performance, which I really loved, that this was fundamental law and the idea of arriving at a fundamental. But did they anticipate judicial review? Did they think it was going to be law in the literal sense that Quock, Walker and company could actually overthrow slavery by decision of judges and juries?
They certainly did not anticipate judicial review as it is presently practiced. The term itself was not, as I understand, was not coined until 1910 by Edward Corwin. But they did, certainly if you read Hamilton 78, and some of the hesitant decisions made in some of the states, they did sense that judges would be able to appeal to parts of the Constitution, a Bill of Rights, and put limits on the legislature. They had no idea that it would be used as effectively or as fully as it came to be, but certainly they were moving in that direction, a hesitant direction, and much bitterly contested. So one shouldn't assume that it came into their heads all at once, and even Marbury versus Madison has none of the importance that the law school teachers give to it.
And just a few facts to fill out that story at the federal level. Remember, I mentioned about the veto and executive review. So governors and presidents were expected to veto laws that they considered unconstitutional. In the antebellum period, prior to 1850, there's one exercise of judicial review on this. It's a case called Marbury versus Madison. In that same period, presidents are using the veto about 24 times to strike down laws, to veto laws on constitutional grounds, laws that the courts of their time would probably have upheld. So you get a little bit of a sense of remember the president or the governor is supposed to be independent of the legislature. And in fact, his salary typically can't be decreased, just like the judges, but his salary can't be increased either, because he doesn't have life tenure, so you don't need to make adjustments for inflation. So he has, in some sense, more financial independence of the legislature than the judges do. So he's made quite independent, and he's relied on. If judicial review had been of federal legislation and the federal Constitution had been the main action, they were expecting federal courts to strike down state laws that were violative of national principles. But if they were thinking that that the courts were going to strike down a lot of federal laws, it is surprising that they didn't, for example, specify the apportionment of the judiciary, the way they talk a lot about the House and Senate, how the electors are to be apportioned. If it's going to be a branch of federal power against the states, like the post office or the mint or the treasury, then that failure to specify is really understandable. But if it's going to be a big overseer of Congress, it's odd that they structured it the way they did. And remember, the first Supreme Court has 6 people on it, which is odd precisely because it's an even number, and so they're not quite expecting, not even until the other Chief Justice Marshall, opinions of the court as opposed to sort of seriatim opinions. So it's a very different practice early on than what it's grown into.
Can I have a show of hands? Give it to this gentleman, and then John, after to Judge McHugh. Put your hand up, Judge McHugh, so we'll know where to run the mic afterwards.
Yeah.
It's gone.
In drafting the 1780 Constitution, what were the principal sources that Adams used? And in particular, did he have the 1778 returns from the towns? And if so, what use did he make of them?
Well, certainly Adams had all the returns. The convention gathered, in fact, they spent some time gathering documents. So all of that information was available to him. He had been writing and thinking. This was sort of his great moment. He had been writing and thinking about this for years. One can imagine his great joy, in fact, of being asked, will you write the Constitution? Because he had been preparing for this for his adult life. This was what he had been working towards. So he was very well prepared.
And the 12 other state constitutions are going to be really important as he's thinking about the Massachusetts experience.
Because this is the last of the state constitutions.
Doesn't he write thoughts on government and right after that declaration by the Congress to establish government? So he has a lifelong love of learning and governments that he puts into thoughts on government even before there's Constitution of 1778.
And then he goes to write Defense of the Constitutions, which you always assign and no one reads. But that comes afterwards. But there you can again see his thought process. He was obsessed with constitutions and law. This was something that was his joy and delight.
I think the biggest influence was the British Constitution, as he saw it uncorrupted. And he thought that he had created the perfect Constitution. The British had created the perfect Constitution, but it had become corrupted, and he wanted that kind of Constitution for America. That's why he was very upset at losing the absolute veto. But that probably was his biggest source of influence.
Doesn't that get back, one of my first questions was going to be that this was actually a conservative revolution. It was a revolution that stood for the rule of law, and didn't the colonists feel, you know, like...
Well, you
Not
asked
one of
earlier the effect of the Constitution on contemporaries. I think most elites, as we would say, thought it was the best Constitution created among all of the state constitutions. And many didn't think that we needed any other federal constitution until Shays' Rebellion. If something like Shays' Rebellion could occur in the state which had the best constitution, then all bets are off. We better have something better. And that fed into, I think, the enthusiasm for a new federal constitution.
Judge McHugh?
I wanted to follow up on the question that Tony asked about a judicial review and the sort of amorphous structure of the judiciary power in the state constitution. There isn't even the kind of loose structure that there is in the federal constitution. There's kind of a hint of it in the Declaration of Rights. Article 30 is pretty strong, but you turn to Article 3 and you don't find any definition of what it is. You don't find any attempt at a definition of what it does. You sort of have to infer the existence of the Supreme Judicial Court from other provisions, like the provision that says you can ask it questions. What do you make of that?
I think it's last and least of the branches, and that's the residue of this colonial experience where the judges really are on the wrong side of the revolution in general. And so even in this one and in the federal constitution, there are lots of powers that the other branches are given over the judiciary, more powers that they're given over the judiciary than vice versa.
Other hand, over here? Or, well, first the one back there because it's closest to the mic, and then we'll come to you.
Is it possible that the 1778 convention, the 1778 Constitution was sent to the towns with no qualifications for voting because it was understood that the convention would be considered at town meetings and there were no qualifications other than residence for voting at town meetings?
That's not right.
True, more explanatory just on kind of Occam's razor grounds, because it explains one more feature, though, is, because remember, when the convention that's proposing the 1780 document meets, it doesn't have property qualifications either, and it's not meeting in individual towns. So it's, I think, part and parcel of this idea that Gordon started us with and that Pauline has also written about, a certain special fundamental law coming from the people and therefore being justly viewed as superior to an ordinary piece of legislation. And that's a part of why it has a kind of a supremacy and foundationalism and superiority. One other group of people who are allowed to be in the proposing convention and in these town meetings who ordinarily are excluded from service in the legislature are the clergy. Actually, interestingly, because they are they're not permitted to be legislators.
A quick comment. Voting in town meeting is always problematic because it's the difference between law and reality. That is that there was a requirement for voting in the towns. There was an element of freemanship. But one can clearly imagine that in the towns of Massachusetts, that when it came time, they would often vote by division. That is, you go on to one side of the room and someone goes on to the other side of the room. And they really didn't look too carefully of, did you have exactly the right amount of property in order to qualify to vote? So it's difficult to make a definitive judgment about voting in the town meeting. However, they were quite explicit that all adult males could vote about the Constitution of '78. Now, that may just have been a recognition of what everybody knew was kind of going on, but nonetheless, that was specific, and it was an eloquent statement.
There was one hand in the back that I said I'd call. It was right here. I'm sorry. John, closer.
In light of the importance of the Massachusetts Constitution and the federal Constitution, how is it that most state constitutions today require the election of judges rather than the appointment of judges.
Isn't that a result of Jacksonian democracy?
That's a very interesting question, and there's no really good book on this, but what happens when Hamilton in 78, for example, and it's here also in the Constitution, if I can find it, a statement that I think is quite interesting. Oh, it's Article, in Part the First, Article 5. All power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents and are at all times accountable to them. Hamilton picks this up in 78, if you remember, where he says, look, what are these legislatures? Who do they think they are? They're just agents of the people, but so aren't the judges. Why do they think they're superior? That's a really radical statement to make. And once you begin to think of judges as agents of the people, maybe representatives of the people. After all, representation is no longer confined to the House of Representatives. It's a kind of leftover debris from an earlier thinking. But the Senates, although not in this Constitution, but Senates later become representatives of the people. And the governor here is considered the supreme representative of the people, and the judges are being called the representatives of the people as well. And since election is the criterion of representation for Americans, not for Englishmen, but for Americans, people turn it around and say, well, if judges are our representatives, maybe we should elect them. And it's that logic carried out that leads to most states, not around here, not in New England, but most states, or at least 37 states, I think, in the last count I had, elect their judges. It's really an extraordinary development, and it comes, I think, from this idea that they are agents of the people, like, in some ways, resembling the other agents, and therefore they should be elected.
I have two responses to that. Part of this is the freak of the winter, that the people in western Massachusetts wanted to appoint their own judges, and a number of them wanted elected judiciaries. And it was a cold winter. They didn't get here. They didn't carry the day. They might not have carried the day. Then there's another reason why nationally we have elected judiciaries is it's the result of Jacksonian democracy, because many judiciaries early on were appointed, and then there was this wave of Jacksonian democracy. The pushback on Jacksonian democracy is the American Judicature Society and this whole notion of merit selection. But there are a number of reasons for that, and they're all wrong, as Professor Wood said. It is a little past 5. I have one question and then a quote from Adams. This is a rhetorical question. Have we been talking about, maybe Chief Justice Marshall or others here, have we been talking about just an artifact of history that is not at all relevant today? Or is this, is this Constitution important to us today? I mean, it's a rhetorical question. I know you know the answer, but I just had to get it out there. We're just not talking about a historical artifact. This document, through all of its amendments, is vital, to the administration of justice. It is a little past. I just want to end with a quote from Adams. Although the detail of the formation of American governments is at present little known or regarded either in Europe or in America, it may hereafter become an object of curiosity. For it is destined to spread over the northern part of the whole quarter of the globe. Indeed, the institutions now made in America will not wholly die out for thousands of years. It is of the last importance, then, that they should begin right. And I'd submit that the Massachusetts Constitution of 1780 began right and has provided a wonderful example for the federal Constitution, not only on the side of the globe that he talked about, but around the globe. And with that, I want to thank all of our panelists and you.
I speak on behalf of all of us to say, Robert, thank you for putting this together. For those of us who know the reality about John Adams, we're not bowed at all. It has been an absolutely breathtaking afternoon. I think you could hear this from the applause. I wish we could go on and on and on. Next year, we celebrate the 226th anniversary. That's a very important 2 plus 2 plus 6 is 10. It's a decade, and so on and so forth. So would you please all come back again next year or at any event soon? And I have to say, it is just wonderful that you took time from your lives at this particular moment to come and share this with us. Thank you very much, all of you.
Now we have a party downstairs, and so you're all invited. And I should say that the first sitting of the Massachusetts Supreme Judicial Court under the Constitution of 1780 is coming up. It's February 20th. And maybe we should have a program about that. Thank you.